Good morning. Welcome to the Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge April Wood. To my left is Judge Julie Flood. Assisting us today are Senior Deputy Clerk Eddie Sanders and Officer Richard Remillard. On the calendar this morning, we have State v. Branche on appeal from Mecklenburg County Superior Court. Nope, Carteret County Superior Court. Counsel, are you ready to begin? Let's proceed.
Good morning. May it please the court, my name is Heidi Reiner. I'm here from the Office of the Appellate Defender representing Mr. Branche. I spoke with the clerk and I'd like to reserve 10 minutes for rebuttal. At the beginning of this trial, Mr. Branche admitted to second-degree murder. This is the prototypical second-degree murder case. If the circumstances of this case are not second-degree murder and only second-degree murder, no killing is. The state, however, sought a first-degree murder conviction on the theory of premeditation and deliberation, and then after the evidence had been presented at the charge conference, asked for an instruction as well on lying in wait. Neither should have gone to the jury. I plan to spend my time today talking primarily about why Mr. Branche is not guilty of first-degree murder because there was no premeditation and deliberation here, but I'm of course happy to answer any questions about the issues that the panel has. If we have time, I'll also plan to discuss two other issues. The trial court's error in admitting hundreds of, over 100 irrelevant, repetitive, and overly inflammatory photos to try to secure a first-degree conviction in this second-degree case. And second, a brief discussion of the trial court's error in failing to sustain defense counsel's objection to the prosecutor's argument that verbal provocation didn't matter in this case.
I have a question about your memorandum of additional authority.
Yes.
You've asked us to consider the 2021 Supreme Court case, State versus Austin.
Yes.
Are you relying on Austin for the proposition that statutory violations are deemed preserved?
No, Your Honor. I was relying on that for the notion that Rule 403 claims and evidentiary claims in general can be reviewed for plain error. So that goes to the issue 3, the photos claim.
Okay. All right, thank you.
Okay. I'll turn first then to premeditation and deliberation. This case requires the court to reconcile two long-standing lines of precedent. The first line of cases, which the state relies on in its briefing, says the actions taken before, during, and after a killing may be evidence of premeditation and deliberation. The second line of cases says that guilty conscience evidence, like flight and hiding a body after the fact, can be considered evidence of guilt, but not evidence of premeditation and deliberation. At trial, the state here relied on things that happened after Bennett was killed in order to prove that Mr. Branche acted with premeditation and deliberation. The majority of the state's evidence, in fact, at trial, was about the recovery of Bennett's body. From the first line of the state's opening statement through the over 100 exhibits that were presented at trial, the state was laser focused on reminding the jury where Bennett's body was found and the advanced state of decomposition it was in. This was horrifying evidence, no doubt, and it had nothing to do with whether the murder beforehand had been premeditated or deliberated on. The only way to square these two lines of cases, I think, which have coexisted for decades in our jurisprudence, is to recognize that in cases where our appellate courts have said that actions after the fact do matter for premeditation and deliberation, those actions refer back to something that happened before or during the killing. In other words, for actions taken after a person's death to have any relevance to premeditation and deliberation, there must be some connection to before. So,
didn't your client admit to shooting his girlfriend in the back of the head and then subsequently burying her, recovering her body, and then burying her again and setting her on fire? So wouldn't that be before and after conduct that the jurors were able to consider?
Just a factual point, there was no burning of the body, but also there's nothing in that from before, in my opinion. He admitted to shooting her in the heat of passion and during an argument that was going back and forth, and when she provoked him, told him that she was going to send him a video of herself giving oral sex to another man. The state's evidence through William Green, which was the only evidence of what actually happened at the time of the killing, was that, I believe the words he used were Mr. Branche snapped, and his reason was overcome. He grabbed the gun that was on the counter, per William Green, and shot her. We don't know, of course, how that gunshot ended up in the back of her head. I think there's a number of factual scenarios that could have been at play, but there's no evidence about that. I mean, just thinking about one's natural inclination to turn away or run, I think suggests another scenario. But the fact that she was shot in the heat of the moment, I don't think speaks to any premeditation or deliberation, nor does the actions he took afterwards, which to me are the actions of someone trying to hide their guilt. Oh my gosh, what have I done? Here's what I'm going to do now. It speaks to that, certainly, and it speaks to a guilty conscience and to his guilt of the crime, yes. But does the fact that he's then, after the fact, trying to cover that up mean that he planned the murder? That's sort of a step too far that I don't think makes logical sense, and I don't think is supported by our precedent.
Well, in State v. Freeman, the Supreme Court stated that the defendant's conduct after the shooting also showed an intent to kill. He did not try to aid the victim, but covered the victim with clothes and other objects so he could not be seen and left him to die. That seems very similar to me to the facts that are before us. How would you respond to the Supreme Court's opinion in this case?
In Freeman, my understanding, this is from the state's memorandum of additional authority.
Yes, it is.
My understanding was that the defendant there, that was submitted for the proposition that contradictory evidence of the state's evidence that contradicts one of the pieces of the state's evidence means that the state isn't bound by their theory.
Well, it says this
Yes.
showed an intent to kill.
Right. And I don't think that there's no premeditation and deliberation, though, in this case. I'm sorry, could you point me to where you are?
I'm in the last paragraph of that opinion.
Okay. I guess the language that's popping out at me here is that there was a statement made approximately a week before the commission of the crime.
Well, that's the first part, and then toward
Yes.
the end,
The defendant did not. I mean, I guess I don't think that you can intend to kill someone in second-degree murder in that moment you shoot them. I don't think that that's the same as premeditation and deliberation. It doesn't suggest that here as far as I can see.
Well, then how would you reconcile or maybe distinguish this case from State v. Rose, where the court says any unseemly conduct towards the corpse of the person slain or any indignity offered it by the slayer, as well as concealment of the body, are evidence of express malice and of premeditation and deliberation in the slaying? Seems pretty clear.
And in Buxton, it says, we hold there was sufficient evidence to find the defendant intentionally killed Mr. Buxton with premeditation and deliberation.
That's Freeman. Is that
Buxton, and then she's talking about.
And I'm talking about.
I'm talking about Freeman.
Okay,
I'm
sorry.
talking about Freeman.
Okay, if I can I'll address Rose first. I guess the specifics of that case, the application of the facts of that case, I would say, are out of line with the general principle that's enunciated in that case. I would point to the language in Rose at page 320 and 321 that says a defendant's conduct before and after the killing may be relevant to show premeditation and deliberation, and was indeed in this case. And I think that's how we reconcile those two lines of cases, is that word may, that it really depends on the circumstances of the case. So in most of these cases, I apologize that I'm not perfectly familiar with the circumstances in Freeman. But in most of these cases, all of them that I've found, there is a group of factors the court is citing, things that happened before, statements or actions. I guess the most obvious one that you can think of is in Cummings, which I think is in Mr. Branche's brief at page 13 or 14. The defendant bought a bunch of black garbage bags that day, killed someone, and then the body was wrapped in those black garbage bags. That action of finding that body wrapped in garbage bags, hiding it in that way, I think is relevant to premeditation and deliberation in that case because the defendant bought those garbage bags that day. That is some link to before the fact that shows actual premeditation and deliberation, a plan, not just panic after the fact. Here, I really don't think there's anything before the fact. Judge Wood, I think the hypothetical or the facts that you gave me from this case was it started with him shooting her. That's during the crime. He did shoot her. He admitted that from the outset. I'm not here arguing that he's not guilty of anything. I just think that, he shot her, he panicked, he's on his lunch break. Like, this was not a planned event. There was no cooling down. The state's evidence, and there's nothing to contradict it, so under Carter and Johnson, the state is bound by this evidence, showed that they were in a fight, an argument. There was this backdrop that she was maybe unhappy in the relationship, and he was maybe unhappy about her work at the strip club and starting to give private lap dances. And then on that day, there was physical violence from her toward him, and there was destruction of property on both of their parts in this fight. And then the threat from her of this video of infidelity was what sent him over the edge. And I think you can, although this is not a manslaughter case, you can certainly analogize it to that sort of classic voluntary manslaughter scenario of walking in, finding your partner in bed with someone else and killing one or both of them, and that being the sort of provocation that makes something manslaughter. Now here, he didn't see her actually in bed with someone else, but she threatened to show him a video of it. So I'm not suggesting that his culpability has been reduced to manslaughter, but that is sufficient to reduce his culpability to second-degree murder. There's no evidence from the state that this shooting happened in sort of a cool-blooded way, or that he had thought about this and made this plan to do this.
Counsel, is it your argument that the provocation and the anger then eliminated or took out the deliberation element?
I think that's right. I think the provocation here is one, shows that, and the testimony from William Green, which says that he snapped or was overcome and lost it, I think he uses that phrase one time, show that there was no deliberation, that there was no premeditation in this case, and that is what reduces it to second-degree murder. And that, because that was sort of the central piece making this second-degree murder, that's why it's also plain error that all of these photos about things that happened after the murder is prejudicial, and plain error, and why, for example, the prosecutor's argument during closing argument that mere words aren't enough was prejudicial, because in fact, in this case, mere words are enough. They're not enough for manslaughter, but they are enough for second-degree murder. So when that is the sole issue before the jury, as to whether it will take out premeditation and deliberation, the jury needs to have the correct statement of the law, and we need to reconcile these cases, because I haven't heard from the state that they think that the guilty conscience line of cases is incorrect. That's longstanding. And in Steele, one of the very specific examples that's given is hiding the body. It says subsequent acts, including flight or hiding the body or burning the bloody clothes and otherwise destroying traces of the crime, are competent on the question of guilt. They're not competent on the question of premeditation. In fact, in Steele, in the paragraph before that, which I believe is at page 511, the court says there's an ample finding of premeditation and deliberation in that case, but they refuse to consider evidence of secreting the body after the killing. And I think logically that makes sense when there's nothing to tie it to a plan or some sort of decision, because honestly, I think human nature to want to evade detection in this moment. There may have been, and State v. Foster, which is 130 NC 666 from 1902, recognizes this, that a person who has killed someone has the same motivation to evade detection or being found out, whether they've committed voluntary manslaughter, involuntary manslaughter, second-degree murder, or first-degree murder. You're going to be in trouble. You've killed someone. Something horrible has happened. What you do after that is something else. There are crimes the state could have charged regarding what happened with Miss Bennett's corpse. The state didn't, and I don't think under our line of cases, without something tying that action of burying her body back to the actions or statements or anything from before her murder, that's evidence of premeditation and deliberation.
Well, how do you respond to the state's argument that the use of the .22 to shoot her, rather than the 9mm that he carried all the time, was evidence of premeditation?
I guess first I would say that wasn't, that's a wholly speculative narrative is what I would say to that. There was evidence, there was testimony at trial that he generally carried a 9mm. There was testimony at trial that various people had not seen a .22 at undefined periods of time. Obviously there was a .22. That's how Bennett was killed. The only evidence of what happened that day is from William Green, and he said, was specifically followed up with and asked where this gun was, what this gun was. And he said, this is a gun that was on the counter right when he did it. He grabbed it, and he had used it in the past, I guess, for shooting small animals in the backyard. The fact that other people hadn't noticed the .22 in the house, I don't think is evidence that contradicts that, the actual evidence about what happened that day in any way. It's pure speculation.
Was that an inference for the jury to make?
I don't think that's a rational inference. So if the, certainly juries can make inferences, yes. But in this case, based on the fact that the state presented hard evidence of where that gun was and where it was grabbed from and what it was for, I don't think then you can overcome that with speculation by some argument that's made on appeal that that's not a rational inference when there's that evidence.
How about
the state, sorry, go ahead.
I was going to say, well, how about the evidence that they were in a fight? It's captured on the church cameras across the street, and so they're in a fight in the yard. He leaves with the children, their children, takes them elsewhere, and then comes back. Couldn't the jury infer that he intended to do something to her, and that goes to deliberation, premeditation?
I guess I don't, that seems like a step too far. I don't think that was argued at trial. I don't think there was any evidence about why he came back other than I don't know that his lunch break was over and they were having this argument. But there's not really much evidence about that I can speak to. I don't think that's a rational inference because there is evidence about what happened after that. They're continuing to have a back and forth fight. And it's at that very moment when she threatens him with this video of infidelity that his reason is overcome, and he shoots her. And if I could just say one more thing about the evidence of the .22 before I move on. If the state had wanted to argue that sort of speculative narrative that no one had seen a .22, so it must have been somewhere else, the state could have chosen not to present that testimony from William Green, but under the decisions in Carter and Johnson, once the state does present that testimony, they are bound by it, and that exculpates Mr. Branche from first-degree murder.
Even if the state presents circumstantial evidence?
I don't think the state has presented circumstantial evidence that in any way rebuts Green's testimony about what happened. His account and the Emmy's account that she was killed by a single gunshot are the only evidence about what actually happened in that house. The state presented plenty of evidence, as Judge Witch pointed out, about what happened before, and There was testimony from, a Good Samaritan who stopped and said she had been hitting him and attacking him and in the yard in front of the children, and there was evidence about what happened afterwards, obviously, that the state tried to use to support premeditation and deliberation. But the only evidence the state presented about what actually happened at the time of her death was from William Green and from the ME. If there are any more questions on that, I'll save my time for rebuttal and address your questions then.
Well, I do have one more question.
Please.
I know you haven't addressed the lying in wait.
I haven't.
All right. So do you agree that if there was sufficient evidence on either theory of first-degree murder, then the conviction stands?
I agree that if this court thinks there is sufficient evidence on either theory, yes. My argument is that there is on neither.
So that would render harmless any error in instructing the jury on lying in wait. Okay, thank you.
Yep, thank you.
May it please the court, my name is Robert Montgomery, and I represent the state of North Carolina in this case. I think it's important first to talk about a couple of legal concepts here that I'm sure you all are very familiar with, but just to make the point that when we're talking about a motion to dismiss, the evidence must be viewed in the light most favorable to the state. The state gets the benefit of every inference. It gets the benefit of resolving all contradictions in the evidence as well. And I think it's also important to think about what premeditation and deliberation are. Premeditation means the defendant thought about killing for some length of time, however short, before he killed. This doesn't mean that there has to be a plan in place. All it takes is a moment for premeditation to occur. Deliberation, intent to kill, formulated in a cool state of blood, and one not under the influence of a violent passion, suddenly aroused by some lawful or just cause or legal provocation. And the cases make clear, Bonnie and Getty are two cases that are cited in the state's brief, that one may premeditate and deliberate, although prompted and to a large extent controlled by passion. The fact that the defendant was angry or emotional is not enough to negate deliberation unless the anger or emotion is strong enough to disturb the defendant's ability to reason. Against the backdrop of that law, there is evidence in this case prior to the shooting and after the shooting that supports premeditation and deliberation, and the jury was properly given the opportunity to render that verdict. So prior to the shooting, there was a quarrel. A witness saw this out in the yard. The witness said that he did believe that the victim here was the aggressor in the quarrel. That is certainly true. But it's important to remember from the evidence that she went inside the house and then he followed her inside the house. He didn't have to go in the house at that point, but he did. He followed her inside, and that is where she was shot in the back of the head one time and killed. It's also important that we talk about the informant's testimony. So I believe the wording, and the defendant talked about the wording in several different ways, but the informant said that they were arguing and that the defendant flipped out, I believe was one of the terms used, that he flipped out. But that doesn't necessarily mean that he could not act with premeditation and deliberation. As I was just reading from the Bonnie and Getty cases, it's not necessary that there be no emotion or no anger. So it's a little unclear what this means when all we have is he flipped out. Certainly the jury was given the opportunity to consider second-degree murder, and the jury rejected that. But just saying that he flipped out is not enough to negate premeditation and deliberation. And even if it were, the Johnson case that is cited by the defendant in the Memorandum of Additional Authority makes very clear that when the state introduces in evidence exculpatory statements of the defendant, not contradicted by any other facts or circumstances in evidence, the state is bound by the statements. So if the state presents evidence of circumstances that contradict the statement that was admitted, then the state gets the benefit of that contradiction. And we know that premeditation and deliberation are usually proved by circumstantial evidence. That is quite clear. So in this instance, the state is not bound absolutely by that statement that was admitted from the informant because there are circumstances that contradict what the informant said. One of those, prior to the shooting, is motive. Now, motive is not necessary to prove first-degree murder, but it can be helpful in determining whether there was premeditation and deliberation. The victim told the defendant that she was having sex with other men. There was evidence that she was planning to leave him. This is certainly evidence that he had motive to kill her. As was mentioned during the defendant's argument, some of the questions that were asked concerning the .22 that was used to kill the victim, there was plenty of evidence presented that the defendant always carried a 9mm pistol. However, in this instance, he shot Kristen Bennett with a .22. No one could remember seeing him in recent memory with a .22. The inference here could be either of two things. One is that he went and got the .22 and brought it back for the specific purpose into that room to shoot her. Or it's possible that he could have already had the .22 sitting there ready to kill her. Those are reasonable inferences from the evidence, and those occurred before the shooting. Then there's the evidence after the shooting. And the Rose case, as was mentioned during the defendant's argument, is very clear that unseemly conduct toward the body after the killing is evidence of premeditation and deliberation. The defendant talks about two lines of cases that the state has not resolved. I can't really find two lines of cases. To me, there's one line of cases that says unseemly conduct toward the body after the killing is evidence of premeditation and deliberation. Still is a little bit confusing, I will admit, but it very clearly says flight is not evidence of premeditation and deliberation. It never says conduct towards the body is not evidence of premeditation and deliberation, and still is almost 100 years old at this point. So certainly cases since then from the North Carolina Supreme Court and from this court have made it very clear that conduct towards the body is evidence of premeditation and deliberation. The Centron case is one that I would like to talk about a little bit. It's a little bit of a strange procedure in the Centron case that was decided almost 25 years ago now, but this court decided the case went up to the North Carolina Supreme Court. This court held that there was sufficient evidence in that case, of premeditation and deliberation. In that case, the defendant and the victim were heard arguing. There was a rifle by the sofa where it was not usually kept. The defendant's wife stepped out to feed her cat and heard a shot. She came back in, and the defendant was standing with a rifle having shot the victim. The defendant then took the body, put it in his shed, kept it there for a while, ultimately put it in his car, drove it around for a while until he took it somewhere to dispose of it. The point of that case is all we had was, in that case, the defendant and the victim arguing, and then the unseemly conduct toward the body. And this court very clearly said that was sufficient evidence of premeditation and deliberation. In fact, when the case went up to the North Carolina Supreme Court did reverse a portion of the Court of Appeals opinion, the portion that said that you could also find second-degree murder in that case based upon the actions towards the body. So the North Carolina Supreme Court very clearly in that case said, this means premeditation and deliberation. It doesn't mean second-degree murder. The Rose case, as I mentioned earlier, very similar as well. In that case, there was a process of removing the body, the bloody bedclothes and personal items, cleaning the apartment, hiding the body in the car, transferring it to another vehicle, transporting it to a remote location. In this case, all those similar things happened. It's not just the conduct towards the body, but also the defendant covered up this crime. He lied about it. He participated in searches for Kristen Bennett. He put out flyers for her. He didn't just bury the body one time. He buried it essentially in the backyard. He went and dug it up when he felt like the authorities were on to him. He put it in a vehicle pretty clearly, took it to a remote location, and buried it again. All of this taken in total, including that the gun apparently that was used was never found and so therefore was disposed of. All of that is after the fact evidence that supports premeditation and deliberation. So there was plenty of evidence from which the jury could find premeditation and deliberation, taking the evidence in the light most favorable to the state, giving the state every reasonable inference, resolving the contradictions in favor of the state. There was evidence of premeditation and deliberation.
Now, counsel, excuse me, I'd like to talk to you about the photos that were introduced at trial. How do you respond to defendant's argument that the introduction of over 100 photographs at trial, including numerous photos of the decomposing body and maggots, was excessive?
Well, first of all, and I did want to be sure to say that the state's position is that that issue was waived. And there was a case as recently as 2021 from this court, State v. Washington, that says that rulings on 403 issues, Rule 403 issues, which are discretionary, are waived if there is no objection and plain error does not apply. So first of all, I wanted to say that. But
So how do you respond to, how do you distinguish this from State v. Austin?
Honestly, and I don't have State v. Austin in front of me. I read State v. Austin. I didn't really understand what it was being cited for when I read it. So all I can say is the North Carolina Supreme Court has never said we're changing our mind about this in terms of whether discretionary rulings can be subjected to plain error review. So until they say that, and they certainly didn't clearly say that in Austin, in the defendant's reply brief, there were several cases, including an unpublished case, I believe, from this court in which appellate courts did review 403 issues for plain error. But the reality is, out of as many cases as there are out there, you can find something. I mean, maybe that issue was not raised by the state in that case. For whatever reason, it was reviewed in those cases for plain error. But the Steen case from the North Carolina Supreme Court, Washington from this court, make very clear that that is the rule. That being said, I do want to address the photographs. And the reality with the photographs is at least some of them were gruesome, but they were not gratuitous. This really is what it is. When you have a body that has been buried for 11 months and you have photographs of it, you're going to get gruesome photographs. Now, defendant contends there were too many of them used, but each photo was used for a purpose. And you have to remember how many different scenes there were here. You had the murder scene where the killing occurred. You had the first burial scene in the backyard or beyond the backyard. You had the second burial scene where there was excavation done there. And finally, you had the autopsy. So we had 4 different places in which it was important to have photographs. And this case is simply not comparable to the Hennis case. The Hennis case is something of the gold standard when it comes to using photographs in a way that are solely to arouse the passion of the jury. And in that case, the photographs were blown up on a screen behind the defendant's head and were gone through a couple of times, very slowly.
But there were 35 photos and 3 bodies. Am I correct? With numerous.
I believe that is correct.
And in this case, we've got 1 body with 1 wound and 26 autopsy. Or was it? Were there 20? How many autopsy photos were there in this?
That sounds about right. What you
No,
said.
26 maybe, Hennis.
I'm not sure the exact number, but a lot of the photographs. I mean, there were photographs from the autopsy and photographs from when the body was dug up, which I believe, Your Honor, you were saying was decomposing. I believe it had decomposed already at that point. So we're basically talking about skeletal remains. But every photograph was used for a purpose in this testimony, and the prosecutor went through them very quickly. This, again, was not something that was dwelt upon by the prosecutor as in heinous. So this case is simply not heinous. Each photo was used for a specific purpose, and there was, again, I believe, if I don't have it right in front of me, but the law is, as long as it's not being used for the sole purpose of inflaming the passions of the jury, then it's okay. These were all being used for a purpose. The state had a right to present its case. Defendant says some things in the brief about, well, he admitted that he shot her. He admitted that it was at least second-degree murder, but the state has the right to present all of its case, and certainly a lot of these photographs were very relevant for purposes of showing that there was premeditation and deliberation. I believe defendant in the argument said something about photographs being not relevant, but I don't think there could be an argument that any of these photographs were not relevant. At most, the issue is whether the probative value of them was outweighed by any danger of unfair prejudice, and that simply was not the case here.
In this case, there were approximately 150 photographs that were shown to the jury, and some of them included the pictures of, the rendering of the bones after they were put back together, and photos of the skull with and the bullet and without the bullet, and couldn't there be some argument that that was just totally excessive and meant to prey on the feelings of the jury with 150 photos of one body?
Well, there were not 150
Well, there were
photos of one
the
body.
tarps and the decomposing.
A lot of the photos, a lot of what is complained about here are, when I look at these photos, are just pictures of people standing over some dirt. I mean, a lot of the photos are just that. When it comes to the body, there was something that the medical examiner testified to about each one of the photographs. And so they were relevant. And really, when you look at the 150, the number that were of the body do not seem to be excessive. Now, could they have used fewer? Yes, they could have, but that's not the test. The test is whether the probative value of them is outweighed by the danger of unfair prejudice, and these photographs simply showed what they showed, and that is that the defendant shot the victim one time in the back of the head and proceeded twice to bury her, resulting in exactly what we got with the photographs.
How many photos were of the body?
I cannot recall right now. I believe the defendant has that in the brief. I'm trying to recall how many there were. According to the defendant's brief, there were 40 full-color photos from the autopsy, and it says 40 full-color photos of decomposed body parts, but I'm not sure if any of those overlap or not. But certainly, I'm sure this court has taken a look at the photographs, and that's certainly, again, some of them are gruesome, a lot of them are not, and it's the state's position that they're not gratuitous. They were used for a purpose throughout the testimony.
And it's your contention that the photos were not repetitive?
They were not repetitive. They showed different angles in every one of them, and there's a case that the state cited that, in which the court said that showing different angles was relevant to the testimony that was being presented, and that's simply what happened here as well. I have a considerable more time, but if there are no other questions, I will say that certainly, as long as this court finds that there was sufficient evidence of premeditation and deliberation, it doesn't even need to reach the question of whether there was sufficient evidence of lying in wait. So either one of those will support the verdict, and there would be no prejudice from the admission of the others.
I am curious, though, as to how you respond to the defendant's brief regarding the issue of lying in wait, when they argued that the only evidence whatsoever that the jury could infer lying in wait from was the fact that she was shot in the back of the head, and there are lots of reasons why that could have been. Do you have a response to the arguments of the defendant?
First of all, I'm not sure there are lots of reasons why that would have occurred. I think there is a reasonable inference that her back was turned to the defendant when he shot her. And so there's a reasonable inference that she was unaware that she was about to be shot. And so, yes, there may be other inferences from that the jury could consider, but that's a reasonable inference, was that she was unaware that she was about to be shot. And the state's position, as set out in the brief, is that a secret assault is sufficient to show lying in wait, according to the case law, which makes it very clear. I believe it's the Allison case that says, if the victim knows of the defendant's presence but is not aware of his purpose to kill him, it still is lying in wait. And so it's a reasonable inference that when your back is turned, like the case of Wiggins, which is also cited in the state's brief, then that would raise an inference that there was lying in wait. Are there other ways that could have happened? Certainly. It could. We don't know exactly what happened. You could have, and I'm not saying this happened in this case, but certainly in other cases, you could have an execution-style murder. That would result in a shot in the back of the head. Of course, that would be premeditation and deliberation. But here, when there's nothing else, we don't even know from the statement that was admitted from the informant why she would have had her back turned to the defendant. So that's the state's position, is that when you have a secret assault, you're unable to defend yourself. That's the whole purpose of the lying in wait portion of the murder statute, is that you are shot without knowledge that you are going to be shot. Then that's lying in wait.
Any other questions?
Okay, thank you.
Thank you.
I want to touch on a few things I didn't get to the first time, and then answer any questions that you all have. I'll start with the photos issue. I'm not suggesting at all here today that the state can't present evidence of its case. It absolutely can. However, the photos that were presented here were beyond the bounds of the generous allowance that is given to prosecutors in this effort. By my count, the state showed about 20 pictures of the so-called clandestine grave behind Mr. Branche's house, about the same number of pictures of the dirt area where her body was ultimately found, at least 14 photos of Bennett's highly decomposed body. There may be more. I'd ask the court to look at the Rule 90 supplement index and the pictures themselves, of course. Approximately 17 photos that showed maggots. And then I think Judge Wood, maybe the photos that you were alluding to, numerous pictures of like rotted, disintegrated jean shorts and sports bras and thong underwear, a pink hair tie, bracelets, press-on fingernails, the sort of things that speak to a jury, make them think of someone they know, inflame their passions instead of deciding this on the actual relevant evidence of this case. In addition, the state showed at least 12 photos of various bones that had been what the expert called rendered, meaning the skin and muscle had been stripped away. Some of those were of just sort of a hand reconfigured, and some of those were of a lower body reconfigured. Opposing counsel may be correct that the expert said words about each of those pictures, but how they were relevant to this case is unclear to me. They're bones that have been rendered down. They don't indicate the gunshot or any other injury, because there was no other injury reported or found during this autopsy. And to drive that point home, the state showed 16 photos of the deceased head and skull in various states. And at least half of those didn't even show the bullet hole that caused her death. And I guess, as disgusted as we all may be looking at those photos, and I ask that you do look at them like the jurors had to, those photos don't speak beyond maybe one or two of them to issues that are relevant to the legal controversy, and they really just should have been kept out by the trial court. Their admission violated the rules of evidence and fundamental fairness, and in this case resulted in a conviction where Mr. Branche will spend the rest of his life in prison, based not on the law, but 12 people's unfairly manipulated emotions.
And you can see that defense counsel did not object to these photos at trial.
Absolutely, and I do point to State versus Austin. I can pull up that language. The Supreme Court in 2021 plainly said, plain error review is available under Rule 10A4 only when a defendant specifically argues plain error for an unpreserved instructional or evidentiary error. This is an evidentiary error. In the briefing, Mr. Branche requested plain error review. And I'll also, I think Austin clearly states that in 2021, but I would also point to the language in Steen, which does in fact say that instructional and evidentiary issues are reviewed for plain error, and then goes on to decline to extend plain error review to, in that case, a specific issue, I believe, about a jury contact, outside contact, which is an abuse of discretion issue, but is not an instructional or evidentiary issue, which Steen also states still is reviewed for plain error. So I think sort of cherry picking that language out of Steen is an unfair representation, and that's confirmed by the Supreme Court's continued statements that 403 evidentiary claims are reviewed for plain error. But yes, Your Honor, it was unpreserved at trial. I think in this case, though, the sheer number of them, as Judge Zachary pointed out, it was 35 in Hennis for 3 bodies. It was over 150 here for 1 body. As I mentioned, most of those just really didn't have a legitimate purpose in this case. And some of them, as I've discussed, were wholly irrelevant. If I could just briefly touch on lying in wait, opposing counsel talked about a reasonable inference that Bennett was unaware she was going to be shot. That is not what lying in wait requires under the case law. Lying in wait requires surprise and ambush is the language that is used in State versus Lynch. And I don't think any viewing of the evidence suggests that here. I mean, from a common sense perspective, they're arguing, they're in their house, she's threatening him with videos, they're having this back and forth. This is not lying in wait. I agree with the state's briefing that, and statements here today that LaRue and Allison, under those cases, it's not necessary for the perpetrator to wait somewhere for the victim or to be unaware of the perpetrator's presence. But in Lynch, it does specifically say that surprise and ambush is required. And so in Lynch, it was a case similar to this. It was a domestic argument situation where the defendant and the victim had been seen together walking through a parking lot, arm in arm. They were heard arguing before, and then he stabbed her, but there was no, from what I can tell from the opinion, no direct evidence of that actual killing. This is like that case. Lying in wait was inappropriate, especially where the state's evidence from William Green said that, quote, this is at page 378 of the transcript, William Green testified that, quote, something clicked off in his head and he grabbed the gun that was on the counter and shot her. So I know some various phrases were used, but that's one that he used and really speaks to the in the moment nature of this shooting. And then I guess just before I wrap up, I'll address the Cintron case that opposing counsel talked about. I would point to the language at page 611 of that case. The court says several factors are proper to consider in determining whether the killing was done with premeditation and deliberation, and it lists a number of them. But the one relevant here is that it said preparations were made before the homicide for concealment of the crime. So the concealment of the crime is after the fact, but there it is explicitly tied to something that happened before the crime. In that case, it's that he had gotten the rifle, and out of where it was normally held and stationed it next to the couch where he was planning to commit the murder. And I will note, I know that I use the word plan as shorthand. I understand what the definition of premeditation and deliberation is. It doesn't have to be a long-term issue. But I think all the evidence here points, and that's the state's evidence, points to the fact that this was a heat of the passion, second-degree murder. And I don't think the state has said, other than pointing to some cases that say desecration of a corpse may be relevant, I still haven't heard why this is somehow evidence of any premeditation, however long or short that premeditation may have been. That is evidence of guilty conscience, absolutely. Like a non-guilty person doesn't flee, they don't hide the body, they don't necessarily burn the evidence. Guilty, yes. Does that show that there was some sort of premeditation or that he had some consideration that this happened in a cool state of blood? I think the answer is absolutely not, and I don't think that without some logical tie-in, it makes sense to hold that against Mr. Branche in this case. Just to close out, this is the quintessential case of second-degree murder. He didn't catch Bennett in the act, but she did threaten to show him video evidence of it, and that, not anything that happened before, was the moment that set him off, according to the state's evidence. The state's argument that there was a .22 somewhere, maybe not somewhere, is not evidence. That's argument that the state made, and I don't think it's a reasonable inference when there is actual evidence that there was a .22 on the counter, and that evidence is from the state. The informant's testimony here proved to be extremely reliable. He pointed law enforcement to exactly where the body was. He told them about a bloody towel, a coworker, all sorts of things that proved to be true at trial. There's no reason to think this evidence from the state wasn't also true. The state failed to present substantial evidence of first-degree murder under either the theory of premeditation or lying in wait. There was no surprise or ambush, and there was no premeditation or deliberation here. The motion to dismiss should have been granted, and he respectfully asked this court to reverse the judgment and remand for entry on second-degree murder, or if this court finds in his favor on the 403 issue, to remand for a new trial. Thank you.
Thank you. That concludes oral argument in this matter, and we'll take it under advisement. I want to thank you both for your excellent arguments today. Mr. Sanders, we may adjourn.
Thank you, you too. Good luck with meeting the girlfriend and all that.